Happy Thursday, everyone. Thank you so much for being here today for another installment in the statewide training initiative. I'm going to turn on the closed captioning because I always seem to forget to do that if I don't do it right away. And I'm going to take a look at our participants and see who we have trickling in. So I know we have a wide range of folks, big numbers that registered for this training. I see we have about 23 that have trickled in so far. So I'm just going to get started with the general announcements. As always, this is being recorded. That recording, with the permission from our presenters, will be disseminated to all registrants at the end of this segment. Usually it takes me about a day or so to get it out to everyone, but don't worry, I will get it over to you. Additionally, we will have a couple of materials that will accompany that recording in the form of a link to documents that will assist you in actually taking on this type of work and doing the best that you can for your clients. Before I go into introductions, I do want to say that this was CLE approved. I know a few times in the past I've ended the webinar without providing the CLE code, but I will be sure to do that this time. It's on my radar. And as always, that CLE code will also be sent along with the recording and the follow-up materials. So don't worry. I'm also an open channel of communication. If you need anything, please feel free to email me directly. I'll drop my email into the chat. And on that note, we would like to use the chat function today in order to engage, our audience. So if you have any questions throughout this presentation that you would like to submit to our presenters, please feel free to drop them in the chat or the Q&A. I'll be monitoring that to make sure that your questions get read out loud to our presenters if time permits at the end. And so without any more, of the standard instructions, I am going to go forward with the introductions of our wonderful presenters that we have here today. So welcome to Supported Decision Making. Today we have Africa Altidor and Jordan Chastain, who are senior staff attorneys at Disability Rights Florida. In this role, they provide legal advocacy and rights protection for adults and children with a wide range of disabilities. Presently, their work at Disability Rights Florida focuses on disputes involving Medicaid eligibility, including protected Medicaid, home and community-based services waivers, and Medicare savings programs. Additionally, they provide legal advocacy for clients wishing to explore rights restoration and supported decision-making as an alternative to guardianship. So without further ado, I'm going to turn it over to our speakers, and I hope you all enjoy today's wonderful presentation.
Good afternoon, everyone. Thank you for attending. This is Supported Decision Making with myself and Africa Altidor. And today I'm going to discuss, first off, what disability rights does, and also go into kind of what we're talking about with supported decision making and guardianship, as well as setting up a supported decision making agreement. And so hopefully you'll have a little bit of knowledge about how to do that when we're done with here today. So first off, Disability Rights Florida was set up in 1977 as Florida's protection advocacy system. Pretty much every state has a protection advocacy system, which protects persons with disabilities, and they get their funding from 9 federal programs that provide grants that address a specific area of disabilities. So some of them might be traumatic brain injuries. Other one might be for technology assistance, any assistive devices. And Disability Rights has been a not-for-profit corporation since 1987. We have offices in Tallahassee, Tampa, Gainesville, and Hollywood, as well as other offices throughout the state, some smaller offices like in Pensacola. And basically we protect and advocate for, any necessities that persons with disabilities might need. So any housing or healthcare, education, those are all areas that we focus on and investigate. We might provide advocacy, or go after any sort of litigation that might allow access or enhance life for persons with disabilities. So today, first we're going to talk about what is supported decision making, and then we're going to talk about what is guardianship, and then terminating guardianship along the way. So let me make sure that I start our And so then we're going to go into success stories and any advocacy tips that we might have, as well as any questions that we have in the chat. So this is the continuum, basically any alternatives to guardianship that we see. So at the top, you see self-determination. That's where, ideally we would have folks make decisions themselves, wouldn't necessarily need any assistance with them. But if they do, that's where we start looking down the list and we see support decision making. And circle of support is something we're going to really focus on today, where we talk about individuals with that use trusted friends or family to help with their decisions throughout the day or throughout the week, whatever they need assistance with. The next would be, advanced directives or living wills. Those are all things that I think a lot of folks on here might be familiar with and might have heard of before. Healthcare surrogates might be something that's kind of outside a traditional practice setting. We may not see that too often. And we'll discuss that as we go along. There's, certainly trusts. We've all heard of trusts and what they do. Representative payee or rep payee is something that's kind of in the middle of the spectrum. That's it's basically only deals with Social Security, and then of course we see the guardianships, which are less rights and more restrictive to the individual. So now just making sure. Africa, do you see the PowerPoint? Do you see it?
Yes, I do.
Okay, thank you. Sorry. So the words to know that we're going to go through, supported decision making is where you allow individuals to make choices with their lives from persons they trust. So that's your circle of support. Also, your guardianship is where, that's certainly, as we talk about, the most restrictive. That's where the decision maker is appointed by the court to make, your personal financial decisions, healthcare decisions, anything that we see. With restoration, that's talking about restoring rights that were removed under guardianship. So, and we'll talk about that more later, talking about voting rights, driving, firearms rights, some of the kind of other rights that, we all take for granted. And those are ones that are removed under guardianship, and you have to kind of work to get those back. Then there's the suggestion of capacity, which if you're trying to remove a guardianship, you're asking the court, you file a suggestion of capacity with the court, and you ask them to restore the individual's capacity to make decisions about their lives. The healthcare proxy names someone to make healthcare decisions only. That's also with a healthcare surrogate. They're similar, but a healthcare surrogate, you don't need an attorney to draft that document. And it's limited, only to medical facilities and health decisions. The AIP is something you'll frequently see discussed. If you look up anything under, guardianship, you might see AIP frequently, and that's alleged incapacitated person. And then the award is the individual placed under guardianship. Now I'm turning it over to Africa.
You there, Africa?
Yes, I'm here. I just requested control from Jordan. Okay.
Oh, fantastic.
So Jordan, if you can just make your screen bigger just from the current slide that we're on. Okay. So I'm going to talk about what is supported decision-making a little bit more in depth. So the example or the definition that I have here came directly from the bill that was in the last legislative session. Basically, it says that supported decision-making means a process of supporting an adult with a disability to assist him or her with understanding the options, responsibility, and consequences of a life decision and enabling him or her to make that decision without impeding on their self-determination. So basically, in a nutshell, what supported decision-making is you have an adult with a disability who is seeking to make their own decisions, and they want to use their families, their friend, a professional, others that they trust in doing so. And so what it is they simply just need help understanding. They need someone who they are able to ask questions and that they are able to get answers in a language that they understand so that they can communicate their wishes to others. So that is what supported decision-making is. And so this next slide, you ask yourself, why do we need supported decision-making? This is some information that I pulled, just some statistics from all Florida courts. And this is from the month of June 2019 until June 2021. And you'll see that in state courts throughout Florida, in the courts throughout Florida, there were 17,000 guardianship cases that were filed. And so it kind of makes you think, well, how many of those cases could have been avoided by using supported decision-making? And so policymakers and scholars in some courts, they've recognized, and it makes sense that even when you have a guardianship and it is functioning as it should, there's still a kind of civil death that happens with that individual, because that individual is no longer able to freely participate in society without the input of others. So then we have to think about ways that we, in alternatives to guardianship, that can still protect and advance self-determination among people with disabilities and among people who have challenges with making decisions. Florida has not yet created law regarding supported decision-making, but there are some other states that are successfully using supported decision-making. In 2013, a Virginia state court became the first court in the country to order the use of a supported decision-making agreement as an alternative to a guardianship. Florida and Kentucky, we followed suit in 2016 and 2017. But it was actually Texas, of all places, in 2015, became the first state in the country to actually pass a law regarding supported decision-making and actually establish supported decision-making agreements as legally valid documents that third parties must rely on. And this is just a list of some other states who are successfully using supported decision-making. They have passed comprehensive legislation related to supported decision-making and put in some safeguards so that that is an option for individuals in their state. And as you can see, Florida is not yet part of that list, but I do think that with our efforts, eventually we will be on that list. And so, as many of you know, there was a bill that was put forth regarding supported decision-making during the last legislative session. However, it did fail. So it is not a law as of right now in the state of Florida, but agencies like my agency and other like agencies, we are still going to rally behind this idea and this notion that supported decision-making is a good thing. It's something that's needed in Florida. because we do believe that supported decision-making is can better the lives of individuals with disabilities. So, I mean, although it didn't pass this time around, it's still going to be a push. And we would just ask that if you do believe in supported decision-making, that you also help advance that cause.
So what is guardianship? And some of you may be familiar with that. But it's basically, it's a legal proceeding in the courts of Florida in which a guardian is appointed to exercise the legal rights of an incapacitated person. So the court will find that, the individual did choose someone else to make some or all of those decisions for that individual. So there may be some rights that are not, basically taken away from that individual. They may, retain the right to manage their financial affairs or other sorts of, rights that they may retain voting or firearms or driving. There may be specific rights that are retained by the board, and that's depending on the type of guardianship. And so in order to be placed under guardianship, there is, there are qualifying disabilities, and some of those are developmental disabilities that might be, cerebral palsy or autism or spina bifida, and those are also covered under guardian advocate proceedings. So if you have a developmental disability, that's covered under guardian advocate. If there's an age-related disability, Alzheimer's, that's kind of probably one of the more frequent times we see individuals placed under guardianship is as they age and they begin to, develop Alzheimer's, and that becomes progressive. You may see individuals placed under guardianship. There's also, individuals with mental health conditions, PTSD, schizophrenia, OCD. And a lot of times, folks will jump straight to guardianship. And as we'll talk about later, that's not necessarily the most appropriate thing. And so others, other times there's spinal cord injury, traumatic brain injury, any sort of acquired disability later in life that pops up where they can't manage, their affairs, and that will also potentially lead to guardianship. So Florida requires the use of the least restrictive alternative. So if you remember that pyramid we saw earlier, sometimes the courts will look at guardianship, but that's not, they're required to look at a least restrictive alternative. So if a trust is more appropriate, or a limited guardianship is more appropriate, or even a temporary guardianship, those are ones that should be considered first. Florida requires that. So the law requires, limiting only to what they need as well. So if they are placed under guardianship, you shouldn't have rights taken away that are tacked on to it that they don't need taken away. So if they're still able to vote, or they're still able to drive, those are things that should not necessarily be taken away in guardianship. They should be more, limited in place. So again, the plenary is full guardianship, and that's the most restrictive to the individual. That's oftentimes what we see is, full guardianship, and those are, the most restrictive because all your rights are basically taken away except for some rights, which I'll discuss in a minute. So if you are, proceeding to guardianship, the petitioner who's petitioning for the individual to be placed under guardianship must state factual information as to why that individual is incapacitated. They can't lie about it. It has to be factual. It has to be based in documentation. And they must state which rights the individual is incapable of exercising and why. So the rights that the individual retains no matter what, that the ward effectively retains, are the right to counsel and, reviewing by the court the need for guardianship and to be as independent as possible. There's some other rights, the right to privacy and a few others that are, always available, but aren't necessarily enforced. It's tough to enforce those rights to privacy when you're under a guardianship. So those are thoughts, that these courts need to consider, and that, attorneys need to consider when when they have clients that are under guardianship. So is guardianship needed? And these are things that, disability rights, has taken the stand that guardianship is, the most restrictive, and it's very, it kind of goes against the individual. And so, when you're taking a case, with a client that they're looking at whether guardianship is appropriate or whether they're already under guardianship, discuss the reasons for why they're on guardianship or why guardianship needs to be pursued. Presume that it's not needed, especially, there's all these other options available, that don't proceed to guardianship, and they can be managed. The individual can have rights and be able to manage their own affairs with these other options. Guardian advocacy is oftentimes seen as less restrictive, but you really just, in order to retain guardian advocacy, you just have to have one right retained. So it's not necessarily less restrictive than plenary guardianship. If you have a younger client and they're going to be placed under guardianship, that can be very restrictive for their future, can be very challenging for them and their future if they want to vote or they want any other rights restored, particularly driving. With younger clients, that's something that's of great interest to younger folks, and so they a lot of those are very challenging to restore if they've been placed under guardianship. The guardians or the advocates have the duty to inform the court if the clients regain capacity and if guardianship is no longer required. So if the guardian feels that the client has regained capacity, whether it's through some temporary injury or they feel that guardianship is no longer required, then it is their duty to inform the court. These are some alternatives that you can use along with supported decision making. Power of attorney, where you share your rights and decisions with the agent. That's something a lot of us are familiar with. Healthcare surrogate, that's something that I talked about earlier. It's only healthcare decisions. You can basically put it out there for the future, saying, if I become, physically or mentally unable to perform, make my own decisions, I'd like this person to make these medical decisions for me. Similar to advanced directives, if I'm unable to make this decision, and I have surgery or I have, receive any sort of psychiatric treatment where I'm unable to make that decision, these are the medications or these are the treatments that I prefer to receive. Information releases are very useful to use along with supported decision making. If you are a trusted friend or family member and that individual gives you access to information from their college or bank, that will be helpful in getting them to make better decisions. Rep payee is specific only to Social Security, and that person will handle Social Security issues and finances. And use of trusts is less restrictive than guardianship, but it still allows the individual to make their own decisions as far as what finances they have in the bank. It doesn't necessarily allow them to make their decisions as far as what is going on with their income level or anything like that. So it's all a trade-off with rights and allowing folks to make their own decisions, which is preferable. When we look to drafting the supported decision-making agreement, this is, the first thing you want is the individual that requires support. You want all their information, that should be at the top of the agreement. The types of decisions that will require support. Those are, whether it's financial, healthcare, daily activities. What do they need assistance with? Do they need assistance with finding counsel? Do they need assistance with, finding a bank, or, where to enroll in school? So those are all things that can be included in a supported decision-making agreement. The more specific, the more, areas you go into with their life, the more thorough the SDM agreement will be. You can always go back and revise it later with the client, but it's better if you flesh all that out ahead of time and make sure that what are the areas you want assistance with in your decisions. And so making sure that they're identifying the appropriate supporters. Or is this someone you really trust? Is this someone you're close to? Is this someone that will help you make these good decisions? And then a very important part is an option for the client to end the SDM agreement at any time if they don't feel comfortable with it, or they don't want a specific person assisting them with those decisions in the future. That option was there for them to end the agreement. And this is what sample SDM agreement looks like. So this is you see a list there of financial affairs, hiring a lawyer, healthcare, personal care. You can certainly tack on a lot more than that. Help me finding a job, help me with decisions about any sort of housing or anything like that. There's certainly other areas that you can add to kind of make that supported decision-making agreement more complete. And this is one with pictures. So some clients may, understand what decision that they're making more with pictures. This might be more useful to certain clients. So if, it's certainly useful to include pictures if that's something that you wish to do.
So now I want to talk about how we would terminate a guardianship using supported decision-making. As Jordan touched on earlier, there are two types of guardianships under two separate areas of the law, Chapter 744 and then Chapter 393. And this is just an overview of how to terminate guardianship in general for either one of those types of, regardless of the type of law that it is covered under. So with both of them, you're going to have to file a suggestion of capacity or suggestion that this person, their rights can be restored. Now with the 744 guardianship, what happens is that the court will immediately appoint a physician to examine the ward, and that physician has to have their report back to the court within 20 days. Under 393, it's a little bit different. There is no physician that's going to be appointed. What you would have to do is allege in your suggestion of capacity that there is evidence to prove that the individual can exercise their rights. And then from there can be different types of court action. If there's no support that is no evidentiary support that is alleged in your restoration under 393, the court is going to immediately set it for a hearing. Under 744, the difference is once your suggestion of capacity is filed, the doctor evaluates your client and submits that report back. If there is an objection to it, or if the evaluator decides that there shouldn't be a full restoration, at that point, the court will set it for hearing. And then from there, once you go to hearing, you'll get a final order. And I'll touch on that a little bit later. But what I want to caution everyone is that, like Jordan said before, you do have a right, the ward has a right to a counsel. The issue becomes that the counsel must be contracted for by one of the guardians or appointed by the court. So yes, there's a right to counsel for that person, but the guardian is the one who's going to decide, or the court is going to decide who's going to be the attorney for that person. So when you're filing your suggestion of capacity, a tip is to ask the court to appoint you as the attorney in the suggestion of capacity. I also want to note that attorney-client privilege. If there's an instance where the guardian is the one who is contracting you to be the attorney for the ward, you have to remember who your client is. It's just like a juvenile and their mom and dad is the one that's paying you, but your client is that juvenile. Your loyalty lies with your client, not necessarily the guardian or the person who is paying you. So you have someone who comes in and saying that they would like some assistance with getting their rights restored. At this point, you need to evaluate the case for restoration. That's you asking questions to gather information to, one, decide if you even want to handle this case, and then get information to put in your suggestion of capacity. And so to do that, you want to ask questions as to each right that has been affected and kind of evaluate the client's ability to exercise the rights with and without support. So you would ask, for example, the right to marry. You can ask the client, would you like to get married? If so, why? What does marriage mean to you? Same thing with the right to vote. Have you ever voted? How would you decide who to vote for? Do you think you can vote? What you would need to do that. And so I want to caution everyone, or kind of remind everyone, is that we have to remember that we can't stand in a role of, say, a parent to this ward. We can't say, okay, this person has the ability to make decisions, but their decisions may not be the best decisions. And therefore they don't have capacity. We have to remember that it's not the ability to make a good or a bad decision. It's the ability to exercise and make a decision is what we're looking for. And so if you think about it from the standpoint of, young people typically don't make the best decisions. However, they have the ability to make decisions. And I mean, 90% of any college campus should be under a guardianship if we think about it, because not all young people don't make good decisions, but that's not what we have to gauge when we're trying to evaluate a case. It's whether or not this person has the ability to make the decision to exercise their right with or without a support. And some additional questions you want to be mindful of and want to ask is, what skills need to be developed by the ward and how can they be developed? So as you go through the rights, if you see that some of them, they're not as he or she is not as strong in exercising that right, there may be something that can be done to develop that right so that in the future you can successfully ask the court to restore it, such as putting in a budget. If the guardian is on board, it always makes it a little bit easier. You can speak with the guardian about, hey, how about we give John a little bit of extra money every month and see how he budgeted his money, see what he uses it for. That way we can tell the court in the future that, hey, John had a budget every month of $100. He knew he had to do this with this amount of money, pay his cell phone bill with this amount of money. So there's things that can be done to develop a certain skill, if you will, to be able to exercise a right. And then you want to figure out which rights are seeking to be restored. That's something that you should probably do initially so that you are not spinning your wheels on gathering information on rights that the ward would feel more comfortable with someone else having. Is there sufficient evidence of capacity to restore those rights that you are being asked to assist with? Because we don't want the court or opposing counsel to feel like what you're putting forth is frivolous. So make sure, I understand that we're all attorneys here, we're not necessarily physicians, but you can kind of get a sense of whether or not there is evidence that I can put forth to show that there is actual capacity for this person to exercise the right. And then think about why the guardianship was even filed. Was this a guardianship that was filed when the child turned 18? Because the school board told mom and dad that, hey, the only way for you to continue to be part of their lives and part of their educational process is to get a guardianship? If so, that's something that can help you in restoring your client's rights, because it may have been something that wasn't needed. Has the initial circumstances changed? Has the initial concern for the guardianship been addressed? If so, that's something you want to allege in your suggestion of capacity as well. And so I touched on it a little bit, supportive guardians and key witnesses. If a guardian is supportive of a restoration of rights, it makes things a lot easier. If not, you take what you get. But you want to kind of find out, does anyone support this restoration? Is it the guardians? Is it family members? Is it some of the client's service providers? Are there other individuals that's seeking restoration? Are there other individuals that would benefit from this person being restored their rights? What are the motives of the person who is supporting the restoration? And what are the motives of the person who are opposing the restoration? So we go on to the suggestion of capacity. When you're filing your suggestion of capacity, if it's a 744, be sure to address every right that has been affected and provide examples in your suggestion of capacity of how the person is actually exercising their rights. And also discuss in your suggestion of capacity whether or not there is a lesser restrictive alternative that Jordan talked about earlier, like a healthcare surrogate, a power of attorney, rep payee, something that can address the concerns of the court of this person being incapacitated. And also, again, ask for your appointment if that is necessary, because once the suggestion of capacity is filed, the court is going to appoint an attorney if the guardian has not already secured an attorney. And if you would like to assist that client, you can ask to be appointed at that time. And so you have to remember, like I said, the 744 guardianship and the 393 guardianship is a little bit different. So when you file your suggestion of capacity, remember the court is going to appoint the physician and they have 20 days to submit their report. Under 393, there is no physician that's going to be appointed. Your suggestion of capacity has to provide evidentiary support that this person can exercise their rights. And the good thing is in 393, in the statute, it actually defines what evidentiary support can include. But I wanted to make mention that it's not just medical documents. So it says, but not limited to a signed statement from a medical, psychological, psychiatric physician. So it's not just a medical document. There can be other things to show that this person has the ability to exercise their rights. But with all of it, you want to provide examples, because if we can show the court that even with the guardianship, this person has a certain level of independence and can exercise their rights, I think that's something that goes a long way in telling the court that this person does have the capacity. And so think about what else you want to file when you file your suggestion of capacity. Letters of support. If the guardians or the co-guardians support the restoration, have them write a letter, have them sign it, have them notarize it to say, hey, my child has grown, has made so many strides since we first had this guardianship. These are the type of things that he or she does on their own. They drive to their own doctor's appointments. They pick up their own medication. They pay their own cell phone bills. Things like that can go a long way to show the court that this person is ready for restoration. And especially if it's coming from the guardian itself, it kind of carries a little bit more weight. But then you can get letters of support from teachers, from family members, medical professionals, directors of community programs. And then you also have Affidavit of Supporters, which is a little bit different. A supporter may or may not already be in the role of supporting your client. So an Affidavit of Support, I'll show you on the next slide, basically just says that, hey, I'm the person that's going to be designated to support John in his decisions when it comes to medical. Or I'm the person that's going to support John in his educational decisions, or how to find a job, things like that. So there can be specific affidavits that are also created and attached to your suggestion of capacity that can show the court that, hey, supported decision-making can work and will work because we have identified these people who will help my client in the process. Also, attaching a resume can be very useful. It can show all the skills and experience that your client has in the real world. Same thing with job evaluations, as well as the annual physician evaluation. Take a look at that and see what is helpful in there and attach that to your suggestion of capacity as well. And this was the Affidavit of Supporters that I was speaking about. It's something that you can draft on your own. There are samples out there where you could use the language that's provided in this one. It basically just says that I, Africa, I'm the decision maker's family friend. I am willing to act in a role of a supporter. I understand my job is to support the decision maker, and I understand that I don't speak for them, that I can only assist them with speaking for themselves, that I will not exert any undue influence, that I will use the information that I have only to support this person in making decisions. And then you see that it can be signed and notarized. I think that that is an important feature because it kind of legitimizes this document and says to the court that, look, this person believes and understands how important it is to be a supporter and that they are willing to do this. And I think it gives the court a little more assurance if the court is going to rely on terminating guardianship for supported decision-making. So once you have filed your suggestion of capacity, if you're under a 744, the court is going to appoint that evaluator to evaluate your client. So you kind of want to speak with your client about the evaluation itself and kind of prepare them for it. One of the biggest things that I find is you have to advise your client sometimes that it's okay to ask questions if they don't understand what's coming at them by this evaluator. It should be a conversation. You should try to explain to them that it's a conversation like you would have with a friend. This isn't a very structured, formal, rigid thing where you have to give a very specific, eloquent answer. It's like you're talking to your friend. If John asks you, hey, how do you spend your $200 every month? You should be able to tell John, hey, I take $50 of it and I give it to my mom for my phone bill. I take $25 of it. I buy my cat food. Things like that. So if your client can understand that this is just a conversation that they're having with the evaluator to show them how they already use their decision-making process, that's really what it is. Also, you want to consider sending the evaluator the evidence that you filed with the court, the suggestion of capacity, because in there you have specific examples of how your client can make decisions and already do make decisions. Attached to your suggestion of capacity were affidavits. I think that's important for the evaluator to also see that, hey, I'm okay with recommending that this guardianship be terminated because I see that there are people in this person's life that will help them make decisions. And also you may have to talk with the evaluator and educate them on how to best communicate with your client. Also consider hiring an independent expert to evaluate your client. Yes, just because the court appointed a specific physician to evaluate your client does not mean that you can't get a confidential evaluation on your own. And sometimes that may be a little bit more helpful in showing that, because it's hard to just fight a client expert's opinion without another expert. So think about and consider hiring an individual, independent expert to evaluate your client as well. And so issues with the evaluation, once you get the evaluation back, you see that it's not as great or not as what you hoped. Kind of go through the evaluation and figure out if there's any issues with it. How long did this evaluator spend with your client? Did they base their opinion on my client's diagnosis and not my client's actual abilities? Are they, is their decision or their conclusion based on paternalistic fears or stereotypes like I talked about before? Young kids don't make good decisions. So because this client is young, I don't want to be the one to say, yes, restore their rights, because I fear that they won't make the best decisions. There is no significant right by right analysis. Every right that was taken away and that you're asking to be restored, the evaluator needs to go through and specifically say why or why not that right should or should not be restored. Is the evaluation too short? Was there not enough information that was actually put in the report? And then sometimes you see that an evaluator will equate the fact that your client needs help with making the decision with incapacity. Just because you need help does not mean you're not able to make a decision. And it holds, sometimes evaluators will hold people with disabilities to a higher standard than someone who doesn't have a disability. And so I put in here, oh, let me go back. I don't know what just happened. I put in here, again, educating others on supported decision-making. And this was actually a screenshot of a report that happened in one of my cases, which I thought was very interesting. This is a standard report that would be filed in Miami-Dade County when someone has been asked to evaluate award for restoration. In this report, you can see that because this evaluator was educated on supported decision-making, this evaluator actually put in the report that supported decision-making as an alternative to guardianship would seem appropriate in this case. To me, that was a big deal. That was a huge step for them to actually recognize that this can be something that the court can rely on. Because we all know as attorneys that sometimes court rely on expert reports way more than any other testimony. So the fact, or evidence, so the fact that this expert actually put in her report something about supported decision-making was a big deal. And then even further, take it a step further, the image on the right, this is the very last page. In those reports, the very last thing the evaluator needs to do is to circle whether or not which recommendation that they think is appropriate. And I want to point out that supported decision-making, that's not part of the standard document that this person filled out. This evaluator actually went in and typed in supported decision-making as one of the recommendations. Ultimately, she didn't circle it, but I think that's a big deal that she actually realized that that was an option. And so I think this goes a long way in saying that it's very important to also educate others in this process along the way on supported decision-making, because you never know when it's going to show up and how it can help you in the long run. And so I just wanted to talk briefly about final orders. So you file the suggestion of capacity, your client is evaluated, you go to the hearing, you get a final order. I just want to make sure that, or caution you to look at that final order. As I stated in the very beginning, you see how many guardianship cases are filed in courts, and things move very quickly sometimes. And sometimes you have physicians that have been appointed that are making opinions on rights that were not even part of the guardianship. I recently had this where an individual, his right to make medical decisions was never under guardianship, but we had the evaluator making assessments or opinions on whether or not he can exercise that right. So if you look at the report in a vacuum, you would say, okay, she said he can't exercise that right. This final order is going to reflect that he can't exercise that right. But you got to say, wait a minute. This was never a right that was under guardianship. A restoration is a time to get rights, not take them away. So you want to make sure that you're keeping a close eye on exactly what the order is saying and making sure that it doesn't include something that was not under the guardianship. And then also you want to consider terminating guardianship of personal property based on the rights that if you don't get a full restoration, based on the rights that are remaining, if it's just rights for guardianship of the property, the guardianship of the person can be terminated. So that's something that you want to consider asking the court for as well. And so I want to share a success story of Michael Lincoln. He is an individual, actually, he was the first person in Florida to terminate a guardianship using supported decision-making. In 2016, a St. Lucie County judge found that supported decision-making was a least restrictive alternative to guardianship for Michael and issued an order terminating his guardianship in favor of supported decision-making. His full story is on our website, on our podcast that you can take a listen to, and he explains exactly how restricted he felt and how he felt that he wasn't himself or a whole person because of this guardianship, and how the guardianship started basically because he was a foster child. And so that is a very interesting story. So if you have time, take a listen to that. But I also wanted to point out that on the right, you see, this is actually from his order, from his court order. Number 2 specifically says that there exist alternative, least restrictive measures concerning the 3 rights remaining, the rights that the court did not restore, and that Mr. Lincoln's framework of assisted supported decision-making can be used in lieu of the guardianship. And so I think that this is a very important piece of information that was added to this order, because the court didn't have to specifically say that supported decision-making could be an alternative. So I think that we're making small strides, but strides nonetheless.
So some additional considerations you might think of when you're kind of getting a client out of guardianship and restoring their rights. Ones that may not immediately come back because there may be some administrative hurdles or whatever, um, are the DMV firearms and voting rights. So traditionally, the courts are supposed to, forward that documentation that the client's rights are restored and that the those rights are supposed to be, those specific rights are supposed to be restored. But sometimes you may find that either those agencies don't get um, contacted, or that the judge will issue the order and they will leave certain rights out that they may not be sure whether they're back or not. And so you may have to go back for additional um, an additional hearing with that judge, or maybe even another judge for a hearing on whether those rights are restored. So that's particularly common in the firearms rights, where you may actually have to have an additional hearing to see if those rights are restored or not. They really should be restored at that hearing, where they're getting all their other rights back, but that's not always the case. So if that happens, you may have to go to another hearing or contact FDLE for the firearms rights, or DMV for the driving rights, or Department of State for the voting rights. So it's kind of a challenge. There may be some additional follow-up time that could be substantial in making sure that your client has all their rights restored, because you don't want it to go 10 years down the road and the client decides to get their driver's license or registers to vote or purchase a firearm, and surprise, they don't have there's still a block on whatever right they're trying to pursue. And it's a lot more difficult probably to get it restored 10 years down the road as it would be just to deal with it at that time. So oftentimes you can call the clerks and see if they've moved the paperwork along, or you can ask the judge at the hearing, okay, are these rights all restored? Just want to make sure before the final order is issued that all these rights are restored. And they may be taken off guard by some of those questions, but it ensures that the client gets all their rights restored as they should. So sometimes the judge will issue full, the client gets full restoration of rights, but fails to list one of those rights, listed here. And so that presents additional problems as well. So these are some resources that we've put up here for you. Of course, disability rights, where we list the types of guardianship, and we have more information on guardianship and SDM. Have WINGS here, which is the Working Interdisciplinary Network of Guardianship Stakeholders. They have some information on guardianship and kind of potentially avoiding guardianship. And then the ACLU has some resources on supported decision making, and making sure folks have the ability to make independent decisions. And if there are any questions, I guess we'll look to the chat.
Awesome. Yeah. So some questions did come to the chat. Thank you so much, but for this incredible educational experience. It's such an important aspect of law, and really, while you were speaking, I was thinking to myself, the insane need for community around folks that are in guardianships to come forward, to stand up, to say, what this person is capable of, and what a simultaneously isolating feeling that must be to have to rely on that, and for folks that don't have it. So thank you so much for sharing all of this.
Certainly been some we've seen some folks under guardianship that certainly shouldn't be under guardianship under any circumstance. And it's a challenge to see because it's very restrictive, and there's been some folks that have been placed in some pretty tough situations because they're very challenging. It's very challenging to get out of guardianship if you're erroneously placed into it. So
I can only imagine. So I know the first question that I saw that came through the chat is the question, does your organization help military veterans?
So yes, we do. I mean, assuming, that there is a, a related disability. I'm not sure, exactly what the request would be. It depends on what, what our grants allow for. There's certain specific types of services that we will assist with. So if that individual, because they're a veteran, that doesn't certainly preclude them from contacting us and see what we might assist with.
All right, and going down, just in order of the questions that came in, and please, if you see one in the chat that I missed, let me know. I see a question here that says, I'm in the process of asking for a guardian of a person to be converted to guardian advocacy for the first time. Oh, I'm sorry, it didn't have a question with it. I apologize. But any advice for somebody in that particular circumstance that's, going through the process of asking a guardian of the person to become a guardian advocacy for the first time?
I mean, it would depend on, they would certainly have to have one of the qualifying disabilities to qualify for a guardian advocacy. We would certainly recommend that they look into alternatives that are less restrictive than that even, if there's a, a trust or a, obviously we wish to see folks under supported decision-making, any of those other categories, healthcare proxy, or healthcare surrogate rather, those would certainly be areas to look into. It really just depends on whether they qualify for, guardian advocate under that. And there's all these, we just gave you a range of other options that may be more appropriate depending on, the situation. So.
And I think those are the questions that came to the chat. I had a question I was thinking, I don't know if it's a controversial question to ask. I seem to be good at that. But, in the example that you showed us of the evaluator who typed in their own suggestion of what the alternative should be. I heard you mention, that's not even on the document. That option isn't even on the document. Why? Why is it something that if it's something that you can have as an option, something that is not automatically there?
Well, the short answer is because it's not a legal option in Florida yet, because we don't have any law that says that supported decision-making is an actual legal option. But I think that just shows the power of educating individuals, because even if someone comes behind me and uses her as an evaluator, she now knows that supported decision-making is an option, and that may be appropriate for other people as well. And so it's going to take an effort of everyone basically to educate the courts and all that are involved in this process that supported decision-making is a thing, that it works, and that it should be considered.
Wow, yeah, that kind of went over my head. I didn't realize that, but of course, why would it be on there if it wasn't a legal option? But I guess that shows the power that evaluators have, right? To step in and say, listen, we're telling you this is the better option, like catch-up law.
Basically, yeah. Yeah.
Wow. Well, I don't see any other questions that have come to the chat. I'll check the Q&A because sometimes I do miss those. Let me quickly check there. I didn't see anything there. And I know you all were going to provide me later on with a link to some of the forms and documents that you discussed through this session. Is that correct?
Yes.
Awesome. So I will send that out to everyone else. If you want to drop it in the chat as well, feel free to, since we have a few minutes. And I will make sure that I get that information over to folks with the follow-up materials. With that, I want to say thank you so much. Thank you for your participation in our statewide training initiative. Thank you for everything that you do, because you really are defending the voiceless and really securing freedom for people, which is the most important right that any of us have. So with that, if you have anything that you'd like to close with, or you'd like to say to the audience, the floor is yours.
Just thank you, today for attending and bearing with us with our technical hiccups. I appreciate you, listening in on this, and it's, SDM is something we're very excited about and something that will give individuals a lot more options moving forward. It's certainly something that, like I said before, there's a lot, guardianship may have its own merits, but there's folks that get into guardianship that, really shouldn't be placed in it and can end up in a very unfortunate situation. So this is something that, we can work with, everyone, attorneys, judges, everyone, to allow folks to make their own decisions and not, be forced into situations that are not of their own choosing.
Absolutely. So I'm gonna, and Africa, did you want to say anything as well?
No, just our email addresses are on the screen. So if you have any questions, please reach out to us. We'll be more than happy to help.
Awesome. And I just dropped the CLE code in the chat. Thank you for reminding me. I promise one day I won't forget. I get so distracted by the content and the awesome things you're talking about that I completely forget about that. The CLE is 5873. Again, that's 5873. I dropped it in the chat. I will also send it out with the follow-up materials to everyone who attended and all registrants. Thank you, Africa. Thank you, Jordan. And with that, I am going to stop the recording.